Originally, the protection of minorities focused on the protection of religious minorities. And from religious minorities, we have turned then toward national ethnic minority groups. And of course, today we would even consider, for example, a minority group based on sexual identity or other aspects. But the traditional protection of minorities means religious, linguistic, and national ethnic minorities. We divide two categories, the European level protection or regional protection and the global level of protection. The global level is comprised of UN conventions, but frankly speaking, it is not focusing on protection of minorities, except for one article in the International Covenant on Civil and Political Rights. The idea is that if everybody has their basic human rights, then protection of minorities is not necessary because all of us are equals and equal human rights to all. This is not what most of the minority groups would agree with. So in the European system, we started to concentrate also on protection of minorities in a more sophisticated way. So within the Council of Europe, two conventions have been adopted. One is the Framework Convention for Protection of National Minorities, and the other one is to protect linguistic minorities. There's not a specific one for religious minorities because there is the freedom of religion and freedom of belief. So it is in the frame of basic human rights, I would say. So we have two existing conventions in the Council of Europe, and you might recognize that I was not mentioning the European Convention on Human Rights as the one protecting minorities because it provides protection only indirectly. Since there is a prohibition of discrimination and there are the basic human rights, but it comes from a different legal approach than the other two conventions.
What kind of cases concerning the human rights of Roma have been pending before the international courts?
Roma cases have been brought both to UN committees in the framework of different human rights conventions and also to European levels, especially at the European Court of Human Rights in Strasbourg. The UN level is good to have, but it's a weak system of enforcement. It's not a judgment, not a court system. So usually the cases which are brought there, it's more for the publicity of that case than the real solution. Opposite to that, we have the European Court of Human Rights, which is a court. So you will have a final judgment and the court has the right to render compensation to the victims of violations. So that's the strongest means or weapon in Europe for a minority whose rights have been violated. And some exciting cases have been brought to the Strasbourg court in the past 20-25 years. First, it started with police brutality, inhuman degrading treatment by the police. And then later, a wider array of cases have been developed. Hate speech against Roma in public speech or online. Also in practicing political rights, not only the Roma minority, but other minorities have a difficulty in practicing their political rights, especially if they would like to have their own elected officials. This is difficult. So this was another group of cases. A lot of cases were relating to segregation in schools. So widely, I would say, protection of children from discrimination, not only in the question of school segregation, but also in the quality of schools, what they could receive.
Could you give us some examples?
The Sejic and Finci case versus Bosnia and Herzegovina is a very interesting one for an international lawyer like me, because in Bosnia and Herzegovina, the constitution is written in the Dayton Peace Accords. So it is special to have a constitution like that, and owing to this characteristic, it cannot be easily amended. The idea in 1995 was, at the adoption of the Dayton Peace Accords, that the three big groups of people living in Bosnia, so the Bosniak, the Serbs and the Croats, would equally have political rights. But nobody really thought about minorities, like Roma and Jewish people, for example, or other minorities' representation in the political system. So in that case, this was the main issue front of the Strasbourg court. And of course, the Strasbourg court said what everybody expected that it would say, that these minorities should also have their right for political representation and to have the ability to participate in the political decision-making. Unfortunately, in the constitutional system of Bosnia and Herzegovina, we do not see that they could amend the constitution or create laws which would help in that manner. This is actually one of the biggest issues or questions of whether the Dayton Peace Agreements and to have a constitution through an international treaty is a good solution or not.
So based on your research, what kind of challenges do you see that the Roma are facing when taking their cases to court at the international level?
Taking a Roma case to the Strasbourg court has several different difficulties. One of them is that nowadays quite often discrimination is not directly happening, but the system is flawed, or there is indirect discrimination. And proving that, bringing the evidence to the court is very difficult. If you want to have a case at the Strasbourg court, you need to prove that you are directly the victim of a violation of a basic human right. But if it's systematic, if the problem is in the whole system, then proving this will be very difficult. And this was one of the main issues in the past 15-20 years in litigation, or what I like to call creative litigation, how to bring cases even if it's indirect discrimination. And this was a challenge for the court to accept, but it has happened in accepting victim status, proof of proving the situation, what kind of evidence they can use. And just to mention one example, statistical records. Nobody thought 30 or 40 years ago that statistics would matter at the court, because in individual victimization it doesn't matter that much. But nowadays we see with the systematic problems the use of that.
Could you give us an example?
One example was a case where Roma children have been put into schools for mentally disabled children in a much higher level than the children of the general population. And it was not a direct discrimination against those students, but indirectly there was proof that Roma children are much more likely to get into schools for mentally disabled children than from the average population. Of course, we could question that a minority would have much higher level of mentally disabled children than the majority population, and this was a sign for lawyers and for others to look for and to figure out that the system has some problems.